Welcome. Good evening, everyone. Welcome to the webinar. We have Spanish interpretation. Won't start it now. I made a mistake the last time. So good evening, everyone. Welcome. We will have Spanish interpretation. Once it's deployed, you'll see the three icons. But we are going to get started at 6:35. So if you need another minute to get a glass of water, take a bio break, please do so. And Claudia, can I provide you some space to provide the interpretation instructions in Spanish?
Yes, of course. Thank you so much. Welcome, everyone. We will be providing interpretation at today's session, and I will be making this announcement in English and Spanish. We invite everyone to please select English if you have limited Spanish proficiency. This way, you will be able to hear the interpreters from Spanish to English. And if you are on your computer at the bottom, you will see a globe that says interpretation. Put a check mark on your preferred language. If you're on your cell phone or tablet, locate three dots, tap it lightly, and put a check mark on your preferred language. And be sure to click Done in order to activate and begin the interpretation. Bienvenidos a todos, buenas noches. Proporcionaremos interpretación en la sesión del día de hoy. Anunciaré este mensaje en inglés y en español. Ya se hizo en inglés. Les invitamos a todos a seleccionar el español si está limitado en su dominio del inglés. De esta manera puede escuchar a las intérpretes del inglés al español. Si está en su computadora, hay un globo terráqueo en la parte inferior de su pantalla que dice Interpretación, donde podrá seleccionar español. Selecciónelo al poner una palomita. Si está usando su celular o tableta, ubique y toque los tres puntitos ligeramente y ponga una palomita en español y seleccione Done o finalizar. Este último paso es muy importante para activar la interpretación. Muchas gracias. Estamos a sus órdenes. Thank you very much.
Thank you, Claudia. So welcome, everyone. We'll be starting in 2 minutes at 6:35. I have enabled the interpretation, and you will be able to locate the small globe at the bottom of your screen. Thank you. Thank you for your patience in getting started. Good evening. My name is Allison Henry, and I'm an at-large member of the Pasadena Rental Housing Board and a tenant in District 3, as well as the lead of the ad hoc committee for outreach and communication. You are all very welcome to this evening's Unlocking Success Landlord and Property Management Workshop. Our sincerest apologies to those of you who attended last week's workshop where we experienced audio issues. Your partnership is key to this success, and as partners, we respect your time. Thank you for coming back and giving us a second chance. It's greatly appreciated. Tonight's workshop will be facilitated by Matthew Siegel, an attorney with extensive experience in landlord-tenant law. He will introduce himself more fully in a minute. We're also joined by Agnes Cho from Beehive Consulting. Thanks, Agnes, for supporting this webinar. And I also extend a warm welcome to any of my fellow board members on this webinar. This workshop is not legal advice, nor does it replace legal advice that you may need to seek for your individual situation. This workshop is designed to answer questions generally, clarify what compliance with the Fair and Equitable Housing Charter Amendment looks like, and to show resources that are to facilitate that compliance and success. We hope that this workshop will answer your questions and prevent the need for you to contact the housing counselors. As many of you know, the Pasadena Rental Housing Board is a new body, and we are currently in the process of staffing up, and our priorities are housing counselors. There is currently a backlog, so please understand that you will experience a delay in response from the housing counselors. Should you need to write to a housing counselor at rentalboard@cityofpasadena.net, please include 1, the date the tenancy began, and 2, the exact address of the unit, along with the question or additional information you need to send. But a few housekeeping items before we get started. Please use the Q&A Zoom function to post questions that we will attempt to field after the slideshow. We can answer general types of questions, but not individual scenarios that may need legal assistance. We have a brief survey at the end of this workshop that we would be very appreciative if you complete. We are recording this workshop. The slides and the recording will be available to the public, as well as emailed to everyone that registered for tonight's workshop and last week's workshop. We will also have a copy of tonight's slideshow in Spanish that my colleague Agnes will put in the chat. And all of these materials will be posted to the City of Pasadena /rental board website. As landlords and property managers, you play a very important role in the successful implementation of this voter-approved law. Thank you again for your attention and participation, and I am pleased to present Matthew Siegel.
Great, thank you very much, Allison, and welcome, everybody. Again, our sincerest apologies for our audio difficulties a week ago. We believe they definitely have been fixed this time around, so this should be much more smooth sailing. Just a brief introduction about myself. I am newly retired, and prior to that, I worked for 26 years for the City of Berkeley's rent stabilization program, 12 years as a combination of a housing counselor, analyst, compliance specialist, and about 10 years as a staff attorney for the agency. In addition, I was in private practice in downtown Oakland, California for 10 years, primarily working on landlord-tenant law. And I also had the pleasure of being elected to the Berkeley Rent Board, where I served as a rent board commissioner for 1 year. So that's just a brief introduction about my background. And I'm really pleased to be here and grateful for the opportunity to give you this very broad overview, like Allison was saying, of the rent control ordinance. I look at it as sort of Landlord 101. This is not a deep dive into any one particular component of the ordinance or a deep dive into any of the regulations that exist or that are on the verge of being passed. It's really just to give you a general sense of how the ordinance works and its major components. So with that, let's get started. Thank you very much. So our agenda for tonight, we're going to cover 5 components of the rent control ordinance. We're first going to talk about notice requirements. Under this ordinance, as landlords, you are now going to be obligated to provide your tenants certain types of notices. And you'll also be required to provide the rent board certain types of notices, and we'll discuss those. Next, we're going to talk about exemptions. Another way to think about it is applicability. And what this section is about is an analysis of what type of residential rental units are covered by this new ordinance, whether they're covered by just a piece of it or fully covered. We'll talk about those. Thirdly, we'll spend a good amount of time on what's called the just causes for eviction. Most rent control jurisdictions have these things. It's called good cause or just cause for eviction. There are 11 of them, and we'll talk about them in detail. I'll give you a couple of examples, not too many, just to sort of flesh out some of the common issues that arise for you as property owners when trying to go forward with certain types of eviction that are outlined in the ordinance. Next, the Pasadena Rent Control Ordinance has provisions for relocation assistance for tenants when certain scenarios arise. There's 5 of them, and we'll touch on those and also go over the current amounts that are currently in place. And then finally, we'll talk about the rents, how the rents are set at the start of a tenancy, and how rents get raised under the ordinance, and how we know there was a sort of this period prior to 2022 when the ordinance was in effect. There was various types of rent increases that property owners were allowed to take. We'll discuss those, and also the ways rent gets increased going forward. There are a few other provisions in the ordinance that we didn't have time enough for this presentation to go deep into. I'll mention those briefly. And then at the end, as Allison was saying, we will have time for some questions, and Agnes will be collating them, and we will get to as many as we can. So thank you very much. Next slide, please. So the first provision to talk about is notice requirements. Under this rent control ordinance, at the beginning of every tenancy, as a landlord, you are now required to give notice to each tenant. And it's not just each household, it's each tenant. So the best practice, even though you might be signing a lease with 4 people in a house, the best practice would be to make sure all 4 tenants get this notice. And what does this notice have to say? 3 things. The notice has to talk about the existence of the actual rent control ordinance. It must inform tenants of their right to petition. And when we talk about right to petition, we're talking about in the future when the agency has their hearings unit in place and hearing examiners in place, there will be a petition process for landlords to raise the rent and tenants to have their rent lowered for various reasons. The notice has to talk about the tenant's right to do that. And finally, it must have instructions on how to access this concept called the rent registry, which we'll touch on later. The good news is this form is available on the Pasadena Rental Housing Board, and we'll give you the link at the end, and you can always find it by just going to the Pasadena Rent Board's website. All right, thank you. Next slide, please. This second category is titled exemptions, and as I said before, another way to think about it is applicability. As a landlord now in Pasadena, you might be thinking, well, what is my unit, is my building covered by the rent control ordinance? The 2 main pieces of the rent control ordinance are eviction protections and also rents, and how rents get increased. So this very first subject, government regulated units, subsidized units, Section 8 units, we are fortunate to have Nazanin Salehi with us. She is currently working with Goldfarb Lippman, which is a law firm, and they are currently the interim general counsel for the Pasadena Rent Board. So for this first piece of applicability and exemptions, we're going to turn the floor over to her. Okay, Ms. Salehi.
Thank you. And I apologize for my voice. I am a little bit sick, so please bear with me. But I wanted to go over this first one because it has been a little bit, I think, confusing for folks as to how this works, in particular where there is a Section 8 voucher recipient who is in one of a unit, essentially, and whether or not that unit would be covered by the provisions of the charter amendment. So the specific language of the charter amendment exemption is that rental units, which a government unit, agency, or authority owns, operates, or manages, or in which a government subsidized tenant resides, if applicable, federal or state law or administrative regulations specifically exempt such units from municipal rent control. And I think the key here is that last phrase, which talks about if there are applicable federal or state law or regulations that specifically exempt these types of units from local rent control. And as far as I'm aware, there are not any state or federal regulations or laws that exempt Section 8 tenancies from municipal rent control. So for that reason, these, as you know, as of right now, these tenancies will, for the most part, be covered by the charter amendments provisions. What you really have to do in order to figure out if it applies is look at the underlying type of unit in which the tenant is residing. So for instance, if everyone else in a building, it's a multifamily building, it got its certificate of occupancy before February 1st of 1995, it meets all of the other requirements and is every other unit or every other tenant is covered, then the Section 8 tenant who is in that building is also likely going to be covered. There's no reason why they wouldn't be. Where it gets a little bit tricky is, for instance, if you have a different type of unit that is exempt. So for instance, and Matthew will go over this, certain single family homes are not covered by the charter amendment as far as the rent stabilization provisions go. So in that case, if there is a Section 8 voucher holder who is in a single family home, that Section 8 voucher holder would be covered by the just cause provisions, but not the rent stabilization provisions, because the underlying unit, which is the single family home, is exempt from the rent stabilization provisions of the charter amendment. So really that's how you have to look at it. If everyone else in the building is covered, then the Section 8 voucher recipients should be treated in the same manner. And if they're exempt for whatever reason, it's a tax credit building or it's a single family home, then the Section 8 tenant would be exempt in that situation. And I'm happy to take questions on this. I know it's a tricky topic, but we can do that at the end of Matthew's presentation. So thank you.
Great. Thank you, Nazanin. Thank you so much. That was great. The other 6 categories of exemption we'll touch on briefly. The first one is hotels or motel rooms, if they are occupied for 31 days or more. If you are in the audience and you happen to be a hotel or motel owner, you need to now be cognizant and aware of the fact that if you have a long-term hotel guest, longer than 30 days, on day 31, that room, which you are thinking is just a hotel room rented at, whether it's a daily rate or a weekly rate, or however you come up with the rate, is going to come under rent control. This is pretty rare. This category of exemption is found in most other rent control jurisdictions. It rarely comes up, but it is there. So if you are a business owner who owns one of these hotel or motel, do be aware that come day 31, your occupant is going to become a bona fide rent control tenant. The next category of exemptions is pretty straightforward. Hospital rooms, dormitory rooms that are owned by that educational institution, extended care type of facilities, those rooms, of course, are also going to be fully exempt from the rent control ordinance. The fourth category is if you as the owner are sharing your kitchen or a bath with your tenant. In this case, again, if you are renting to somebody and they're in your unit, it could be a single family house or not. It could be a condominium unit. It could be an apartment unit. But of course, you as the owner have to be living there. And if you're sharing the kitchen with your tenant, then that unit, as long as it's your principal place of residency, will be fully exempt from the rent control ordinance. I'll get to the fifth one at the end because it's an interesting type of exemption. The sixth one are what is commonly referred to as either inclusionary units or density bonus units. And these are units that most commonly are created from a developer who, in most situations, is building a complex from the ground up. And cities will often have these requirements called inclusionary units or density bonus units, in which a certain percentage of these units have to be made affordable at certain affordability levels, whether it's low income, very low income, moderate income, things like that. And those determinations are made by the city, either through a planning commission or the zoning board, or city council. And it's usually going to be a percentage of the units of the building. Those types of units do have the eviction protections of the rent control ordinance, but the rents are going to be regulated by the city. The density bonus unit is simply a situation where a property owner, maybe they are restricted to only going as high as 5 stories in a certain part of the neighborhood or town. And let's say they want to go to a 6th floor. The city decides to grant it, but the trade-off might be this thing called a density bonus. So the city is basically saying to the owner, we'll give you an extra floor where you could put in an extra 5 or 6 units or whatever the number may be, but you have to make some of those units affordable. That's a density bonus unit. And those types of units are also going to be exempt from the rent control provisions of the ordinance, but not the eviction protections. This other category, and Naz referenced it in passing, has to do with a state law called Costa-Hawkins, named after, I think, the California state senators who passed the law. And Costa-Hawkins basically says that units built after February 1st, 1995 are going to be exempt from the rent control protections or the rent control provisions of a rent control ordinance. What Costa-Hawkins also did, just as an aside, is create what's called vacancy decontrol, which basically means anytime a unit that qualifies, built after February 1st, 1995, and we'll talk about single family homes in a second, when there is a turnover, when there is vacancy, the landlord is free to go to market and reset the rents. Single family homes that are rented for the first time after January 1st, 1996, are also going to be exempt from the rent control provisions of the rent control ordinance, but not the eviction protections. And when I say rented for the first time after January 1st, 1996, the way to think about it is fresh. So you can have a tenancy, that might have been rented for decades, but if you have a turnover after January 1st, 1996, then every subsequent new tenancy you will be exempt from the rent setting provisions of the rent control ordinance. The 5th bullet point up here, temporary tenancy, is an interesting one in the ordinance, and it's found in section 1804 with all the other exemptions. And what this does, it basically allows a landlord to have a temporary tenancy. And so the question is, what is a temporary tenancy? Well, first, it has to be in writing. It can't be verbal. Second, it can't be longer than 12 months. It could be 1 month, it could be 11 months and 29 days. And then the most important thing to realize if you are a property owner, and this is interesting to you, is you can't have a tenancy, you can't have your tenancies sort of aggregate more than 12 months in any 36-month period. So how does that work? So let's say, for instance, I'm the landlord and I want to rent to a visiting professor for 9 months. So I put it in writing, it's for 9 months, the professor leaves, and I think this was great and I'd like to do this again. Well, within any 36-month period, I can only rent it for 3 months. So it's the 9 months plus the 3 months. I can't rent it for longer than that. I mean, I could rent it, but it's not going to be exempt from the rent control ordinance. So there are probably policy reasons why this was put into the ordinance for both ways, sort of the way, the provisions of either trying to give property owners some space to provide these types of rentals that are relatively short term, probably more than your sort of average Airbnb, but less of a more formalistic, longer term type of tenancy. And the trade-off was you didn't want this to be used as a way to get around the rent control ordinance by just constantly doing this. So those are sort of the exemptions and the applicability section of the ordinance that help guide you to figure out, is my rental unit covered by the ordinance? And if so, is it fully covered or just partially covered? All right, thank you. Next are the eviction provisions and the eviction protections that are afforded to tenants. And we'll spend some substantial amount of time going over these, one, because there are 11 of them, and I do want to discuss all of them. Some will be rather brief. And the way I like to think about it is to break it up into two different sections. One is no fault, where through no fault of the tenant, the landlord wants or needs to evict. And the other is fault, where the tenant has allegedly done something to warrant an eviction. So the first category is when the landlord is doing what is called necessary and substantial repairs. And there's four things to highlight for this type of eviction. And the first thing is very important as a property owner. You need to have all your permits in hand. You can't be waiting on them. You can't be thinking about getting them. They can't be in the pipeline. You have to have them all in hand before serving your tenant an eviction notice based on this provision. Second point is the repairs have to be needed to bring your unit into compliance with all applicable codes. What that means is generally all applicable housing codes, and just again in a more generic fashion, that's going to be your general habitability code requirements that deal with heating, plumbing, electrical, the big ticket items, because that's going to be a substantial repair generally. And you can look to the city's housing department to further flesh out whether or not the repairs that you are contemplating are needed to bring the unit into compliance. The third thing that's also very important to be aware of, even if you have all your permits lined up, even if the repairs are needed to bring your unit into compliance with applicable housing codes, the city needs to have made a determination that the tenant needs to vacate. So that is something that's also very important to keep in mind. And then finally, it's important to note that this is a temporary eviction. This is not a permanent eviction. When the repairs are done, the tenant has the right to return at the old rent. And in addition, if there are any vacant units in the property at the time, the tenants have the right of first refusal. The second cause for eviction is grounded in California state law, something called the Ellis Act. And you can find that in Government Code 7060. It is quite complex. It's very wordy. There is a lot of notices that are filed. There are certain deed restrictions that go with a landlord doing an eviction under the Ellis Act. And the Ellis Act is basically the landlord telling the world, telling the tenants that I don't want to be in business anymore. I still might want to own this piece of property, but I don't want any more tenants for whatever reason. It basically allows a landlord the ability to evict all the tenants. It has to be all. You can't pick and choose under this Ellis Act. And the Ellis Act does come, according to the city of Pasadena, with certain relocation benefits, which we'll talk about in some subsequent slides. And at this point, I just want to offer sort of a best business practice for most of you listening today. And that is, like Allison was saying at the beginning, this presentation is not legal advice. But if I can give you any words of best practice, it would be that if you are contemplating an eviction, you want to do one, you need to do one, I always believe it's best to consult an attorney. Some of you in the audience might be attorneys, and you're totally fluent in being able to do an eviction. Some of you might have done them yourselves and are very fluent in the court process and how to do it and what type of notices to get served. And some of you are not. And the reason why I always try to advise property owners to go at least consult with an attorney is because the eviction process can be tricky. It can be complicated. It can be highly technical in detail. And what you don't want to do as a property owner is have good cause to evict and lose your case somewhere down the line on a technicality. And the courts, when looking at evictions, do pay careful attention to the technical aspects of an eviction. Is the notice correct? Was the notice filed in time? Is the right language in the lawsuit? Things like that. Things that otherwise in other types of litigation, whether it's a personal injury case, contract case, courts might not be so concerned with, because evictions generally do go faster than most types of lawsuits. The trade-off that the courts and the California legislature has done is to really ensure or sort of compel property owners to dot their I's and cross their T's. So that's just an aside. And with the Ellis Act, it's even more so because it is quite complicated. The next category of eviction for no fault is when the government orders the building to be vacated, and the most common example would be in case of a disaster like an earthquake where the property gets red tagged. And again, as with the first category up at the top, it's a temporary eviction. The tenant will still have the right to return. The next one is an owner move-in eviction. And most, if not all, rent control jurisdictions that have eviction protections will have this as a good cause for an eviction. And going down the road in the future, I can definitely foresee the Pasadena Rent Board doing a full workshop just on owner move-in evictions. I've done them in the past. There are a lot of moving parts. There are a lot of components to an owner move-in eviction. A lot of forms get filed. There's a lot of protections in place. And I'm just going to touch on 5 sort of bullet points about an owner move-in eviction. And the first thing is, who can do an owner move-in eviction? Well, certainly yourself as the owner, but you could also do an eviction to move in your spouse, your domestic partner, your parent, your adult child, grandchild, or grandparent. This is sort of the familial tree for which you can do an eviction to move that type of person in from the family. The second thing to be aware of is, in order to do an owner move-in eviction, in order to be a plaintiff, in order to have your name on that lawsuit to evict the tenant, you have to own at least 50% of the property. And the way to think about it is, if there are 3 brothers and they all own it equally, 33 1/3%, no eviction. If there are 3 brothers and one owns 50% and the other 2 own 25%, the one who owns 50% is the one that can do the owner move-in eviction to move in that part of the family that they want to do so for. The third piece, and of course the second one is important, certainly as a property owner. If you do own the property with other individuals, you want to make sure you own 50%. And also from the tenant perspective, you want to make sure that the person evicting you also owns 50%. Third piece of an owner move-in eviction is that, as with the Ellis Act, there are relocation benefits and moving expenses that will flow to the tenant when this type of eviction takes place. Fourth is that if you go forward with an owner move-in eviction, there is a presumption that you have to live there consecutively for 36 months. If you don't do it, you could potentially be liable to the tenant in some future action. And that action, in most cases, would be an affirmative lawsuit. The tenant attorney community would call it a lawsuit for a wrongful eviction. And just quickly, I won't go too deep into it. This 36-month rule is just a presumption. There can always be sort of an extenuating circumstance as to why you might not have complied with the 36-month rule. But again, all these are super case specific and fact specific. I just brought it up so you could be aware that that rule is in place. So you don't want to have as a game plan to do an owner move-in eviction, live there for 2 months or 12 months or 24 months and then move out, as sort of your thinking, because you could ultimately end up facing some sort of liability. And finally, just for purposes of this overview, there are tenant protections in place that would prevent an owner move-in eviction, even if you have met these previous requirements. And those protections are the tenant had to have lived in the property for 5 years or more, so a minimum of 5 years. That's a starting requisite. Then if the tenant is either 60 years old or older, or terminally ill, or disabled, that would stop you from going forward with an owner move-in eviction, even if you might otherwise qualify. And again, there are other moving pieces and other moving parts to an owner move-in eviction, but because of our time constraints, and because it might not apply to the 46 of you here, and this is supposed to be more of an overview, we don't want to get too deep into it. All right, thank you, Allison. Next slide, please. So next we have 7 grounds for an eviction where the tenant has allegedly done something wrong. The first one is pretty self-explanatory. We don't have to spend a lot of time on it. It's your basic non-payment of rent case. The only thing I do want to add is, the state of emergency for COVID, the statewide state of emergency with COVID has expired. I'm aware that most counties and many cities had eviction moratoriums in place with some rules and procedures that deal with back rent, like unpaid rent during the COVID era. So you just want to be aware that if you are thinking of trying to evict your tenant for non-payment of rent, and if some of that rent goes back in time during the COVID era, you definitely want to talk to an attorney to make sure you are able to go forward with that eviction. Some jurisdictions will prohibit that. And again, I'm not familiar with what Pasadena's rules are or what LA County's rules are. But certainly if you're looking at a tenant that owes you a lot of money for a long period of time, again, you want to sort of talk to an attorney first to make sure, just how much of that you can go after in an eviction. The second good cause for eviction where the tenant is at fault is when the tenant has breached the lease. They have violated some provision of the rental agreement. And the most important thing to realize for this type of eviction is that the breach has to be both material and substantial. And so what does that mean? Well, the law does not define what is material or substantial. It's quite subjective. And for purposes of this presentation, we would look at just sort of common sense. And the first thing would be material. Now, some of you might have rental agreements that are really long. If you're more of a corporate type of property owner with a lengthy lease that's 15, 20, 30 pages, which I've seen with 75 or 80 provisions, you should know that not every provision in that rental agreement is going to be deemed material. You might even have a provision at the end that says all provisions are material. I'm not quite sure that that would survive, but that's going to be up to a judge should that become an issue. So what is material? And like I said, not all provisions are created equal. So for instance, you might have a provision that the tenant has to put out the garbage cans in their house by 4 p.m. on a Tuesday for a Wednesday pickup. And somehow you find out the tenant has violated that lease provision. Using your common sense, that's not going to be a material provision of the lease. What is material? If we look at it as a spectrum, well, certainly paying the rent is material. When the rent gets paid is material. Terms such as maybe a no pet clause, or no smoking, things that really, go to the livability of the unit will generally be looked at as material. But again, it's going to be case by case. I'm not aware of the case law that actually defines what is material. And again, that sort of creates the problem for a property owner when contemplating an eviction, which again, I always come back to, my best practice, which is to consult an attorney to go through it. Because a lot of times, if you're in this situation and you have a tenant that is doing something that you think they shouldn't be doing, it's often going to get, it could often get sort of emotional because of the relationship. The second piece of the puzzle is it has to be substantial. And again, looking at on a spectrum for purposes of this presentation, let's say it is material. Let's assume a no smoking provision is a material provision. And you're aware that one day the tenant was smoking on an exterior common hallway. Well, that's a breach and it's material. But if all you've got is one instance of one cigarette, you need to think about, is that substantial? In my personal opinion, probably not. Now, if you have evidence that this tenant is just smoking a pack a day and has been given a notice by you to stop, and they're continuing to do it, and you have a good case to prove that, it's probably going to be substantial and material. But you can see that there's a spectrum. And where things get difficult is when you get sort of closer, to the middle of that spectrum, where you're sort of in a quandary and trying to make a judgment call as to what it is. But you need to be aware that not just any old violation is going to warrant an eviction, and it does have to be substantial. The third provision for an eviction for where the tenant is at fault is when the tenant has committed a nuisance and or created substantial damage. I'm going to focus on the nuisance component. The rent control ordinance defines nuisance as a tenant unreasonably interfering with the comfort, safety, or quiet enjoyment of other tenants or tenants or occupants in an immediate adjacent property. And I'll get to that at the tail end. So again, as with substantial and material, the law doesn't quite define what is interference with comfort or safety. So the way I like to think about it is we're talking about someone's conduct, talking about the tenant doing something that is substantially bothering other people on the property. And these could be things like harassing, stalking, threatening, things like that. It could also be excessive noise, constant partying, things like that. And you can see how this sometimes will dovetail, excuse me, into the breach of the lease point raised above. So again, you get into these judgment calls where you have to sort of at a time step back and think about it. And again, often consult an attorney if you have a situation like this. The immediate adjacent component is interesting in this ordinance. So it's not just the tenant interfering with other tenants. The ordinance says if they're interfering with an immediately adjacent property. I don't believe there's a regulation yet in effect. If there is, I apologize. If not, I'm sure would think that the rent board would be passing one shortly. Again, for me, common sense tells me that would be the property to the left of me, the property to the right of me, maybe the property behind me, but that could be questionable, and probably not the property across the street. I don't think across the street would qualify as adjacent. But again, there is room in the ordinance for something like that. Most rent control jurisdictions don't have that provision. It's usually limited to conduct that's taking place on that property with other people on that property. But here, there is space if you believe that one of your tenants is creating a nuisance for other occupants on the adjacent property. The fourth one appears pretty straightforward. If the tenant is using the unit for an illegal purpose, such as the sale, possession, or the manufacture of drugs, the only thing I can offer for this is if you find yourself in this type of scenario, you're probably going to want to have some documentation. And of course, that would probably be best in the form of either, police reports, arrests, convictions, things like that. But, do be aware that a police report and an arrest are not, is not proof of that they actually did it. It's just an allegation. A conviction would be different, but it certainly would help your case as a property owner going forward. So if you find yourself in this situation, you want to take that seriously. Definitely, I would advise to consult an attorney because you're going to be talking about, a very serious offense. The fifth one, we called it refusal to renew the lease. And this occurs, and we do see this in other rent control jurisdictions, is when you want your tenant to renew a lease. And the most common example would be a one-year rental agreement. And the household moves in. It's somewhere around month 9 or month 10, maybe month 11. And you want the tenant to renew because you always want your tenants to be on these one-year leases. And you tell your tenant it's time to renew. And it's time to renew, and the tenant does not. And the tenant is upfront about it. I don't want to renew. I don't know what I'm going to be doing next year. I don't want to be locked in. Well, once that lease expires and the tenant is still there, that would be a good cause for eviction because they failed to renew when you asked them to. And the thing to keep this in mind is it has to be identical terms. You can't switch up one lease with another. That's substantially different. You can't take a 2-page lease and give them a 10-page lease and ask them to renew. You can't change the terms from smoking to non-smoking, pets to no pets, things like that. Of course, the amount of rent will change based on the law, but the terms have to be pretty much identical to that first rental agreement. So that's where that provision comes into play. The sixth ground is when the tenant denies access after being given written notice. And this is found in California state law. California Civil Code 1954 actually governs your right as a landlord to cross the threshold and enter a tenant's unit. You do not have sort of an unfettered right to come in because the tenant has what we would call a possessory interest to that unit. They don't own it, but they do have an interest in it. And again, it's they have the right to be free from unwarranted intrusions. And the most common grounds under California state law for a landlord to enter the unit is, of course, would be an emergency, to do necessary or agreed upon repairs, and to show it to prospective tenants, appraisers, buyers, realtors, if it's being put on the market, things like that. And of course, if the government is compelling the landlord to get in for some form of inspection. You do have to give the tenant written notice. 24 hours is presumed to be reasonable. Of course, if it's an emergency, you don't have to give written notice. So if, for instance, you get a call from a neighboring tenant, I'm smelling gas in apartment B, and you go over and you smell gas, and you're pretty sure it's coming from apartment B, you're allowed to enter the unit. The written notice should state the day you're coming in, the time you're coming in, and why you're coming in. And as far as the time, you probably don't want to be open-ended. You don't want to say, I'm coming in Tuesday sometime between 8 and 5. You want to be as specific as possible as a good practice. Now, obviously, if you're coming in to do repairs and you think the repairs are going to take 4 hours, but you're not sure, you want to sort of express that in the notice. And in most of these situations that I've experienced as a private practitioner and at the rent board that I worked at, most landlords and tenants are able to work these things out, because a lot of times we're talking about repairs that all sides want to be done. Number 7, I'm just going to touch on really briefly. The ordinance here allows for an eviction if at the end of the lease, there is a subtenant in possession and they're the only person in possession. And we can do a deeper dive, but we don't have the time for tonight, about the concept of subtenants and what rights they have and what constitutes a subtenant. So I'll just give you the really simple example, and hopefully that helps. I'm a tenant. I have a 1-year lease. Month 9, I'm going to go away. I'm going to go study abroad. I let the landlord know there's no problem. I tell the landlord I'm getting a subtenant. The subtenant is Jack, and Jack moves in, and the lease expires. And then I write to the landlord and I say, I'm never coming back. I'm loving it where I am. I'm out. Well, if Jack is still in possession at the end of the lease, not right away, then that would give you a good cause for eviction. And I know that's probably the most simplistic example. And should you find yourself in a situation like this, your facts could be definitely different, but just I wanted to flesh that out again in the most broadest way possible. All right, thank you very much, Allison. Next slide, please. So as with the notice requirements we talked about earlier on at the top of the presentation, if you are going forward with an eviction under the ordinance, you have to give the tenant an eviction notice. And that notice has to state the grounds for the eviction. As a best practice, I would advise that you actually cite the provision in the ordinance and the section, as opposed to just saying, I'm evicting you based on nuisance. You want to say, I'm evicting you based on nuisance pursuant to section 1806, I think it was, I'm not sure, and whatever subsection it is, and you probably want to describe in sufficient detail the conduct. You also must allege compliance with this law, with Article H. You do have to file the notice with the rent board. We talked earlier at the beginning that there are new notice requirements, and some notices have to be turned into the rent board. This is one of them, and it has to be done within 3 days of serving the tenant. In addition, there has to be a form attached to your eviction notice summarizing the eviction protections that accompany the notice. And if you don't do this, these notice requirements, that could be a defense, excuse me, by the tenant should the case end up in court. And as with some of the other things that we'll talk about later for relocation assistance is required for these types of no-fault evictions. All right, thank you so much, Allison. So the Pasadena Rent Control Ordinance, embedded in its eviction section, which is 1806, provides for relocation assistance and moving expenses in 5 circumstances. 4 of them are evictions, and 1 of them is not. The 4 for evictions, in which the landlord will be obligated to provide relocation assistance and moving expenses, is when the eviction is done for necessary and substantial repairs, owner move-in, an Ellis Act eviction, and the government order, the red tag, or a demolition order. The 5th one is interesting in that if you have a tenant and somehow you are eligible to raise their rent above the annual general adjustment, in this case, it's currently 2.75%. And if that increase is in excess of 5% plus whatever the AGA is, and that tenant and that household cannot pay that increase, then relocation assistance also will be mandated. And the ordinance spells out, and there are certain procedures and requirements that flow from this type of relocation expenses. And again, because of our time constraints, we didn't want to get too deep into it, but for tonight, it's just good to keep that in the back of your mind. So I think probably if you had a unit that was exempt under Costa-Hawkins, that would allow you to raise the rent above an AGA because you're not controlled by the rent control provisions, and you decided to raise the rent 12%, if the increase is 12% plus 2.75% and the tenant is unable to pay it, be aware that relocation benefits might end up flowing to that tenant. So next is actually the chart of the current dollar amounts for relocation assistance for the evictions for the type of things we were talking about, the 4 evictions and the 5% rent increase. And the dollar amounts are based on 2 things: the length of the tenancy, which you see on the left-hand side, and flowing to the right is the bedroom size. And in addition to the dollar amounts, for relocation, there are also moving expenses. And these figures are published by the Rent Board each year, and they're based on fair market rents of the surrounding area. In addition, there are extra relocation benefits for special circumstance households. And that would be if the household has someone who's 60 years or older, or disabled, or terminally ill, or the household has a minor child, these extra payments kick in. This is a little bit similar to the OMI tenant protections, but this one adds a minor being in the household. Just want to see how we're doing with time. We're doing okay. So the last 2 things that we want to talk about is the rents. And the first part of the discussion is, how do I set my rent? Or how should I have set my rent? So while the ordinance, Article H, went into effect December 22nd, 2022, there was a rollback or a rent reversion, provision that looked backwards to May 17th, 2021. And so if you had a tenant in place as of May 17th, 2021, and that tenant is still there, that rent on May 17th, 2021 is their initial rent, their base rent, their starting rent. The increases under rent control currently is 2.75%. And what's important to note about that is that the increase can be taken by you anytime between October 1st, 2023 and September 30th, 2024. The increase is not linked to a calendar year. It's not January through December. It's not a fiscal year, July through June. It's this 12-month period. You can take it any time in this 12-month period, but if you don't, you lose it. And that's what this next bullet point is basically saying. The AGA can be taken anytime between October 1st and September 30th, and there is no banking. And what no banking means is that if you don't take this 2.75%, you will not be able to take it next year, 2 years from now, or 3 years from now. So you can't put these AGAs in your back pocket and sort of save them for a future date and then take them. That's prohibited under this ordinance. When you're raising the rent on a tenant, there's a rent increase notice. And that notice has to, of course, tell the tenant what the rent is being increased to, but it also has to tell the tenant about the existence of Article H and their right to petition. A little similar to that initial notice that you had to provide to your tenants at the beginning of the tenancy. The thing also to be aware of is that your annual general adjustment will not be allowed if there are severe code violations, or if there's an order of the board, or if you're out of compliance with the article. Severe code violations would probably manifest itself from some sort of housing code inspection from a housing inspector. It might manifest itself in the future through a rent board hearing, perhaps filed by a tenant, things like that. An order of the board would probably come in the future through a rent board hearing process where you might have a hearing examiner hearing the case of a tenant seeking to have their rent reduced or claiming their rent is too high, and you might get a decision that there's severe code violations or some other bases for you being unable to take your increases. And I know that's a very broad brush statement, but again, the hearings process is not quite fully in place yet. But once it is, that's where this concept of an order of the board would most likely come from. And non-compliance with the article would be if you're out of, that's okay, if you're out of compliance with most of the provisions of this ordinance. Okay, next slide, thank you. Just one second. So for this slide, just want to touch on rent increases before a few weeks ago, before October 1st, 2023. So as the last slide said, if you have a sitting tenant now and they moved in before May 17, 2021, well then as of May 17, 2021, that was their initial rent, and you would have been able to raise the rent 6%. And I want to emphasize would have, and I'll get to that in a second. If you had a tenant that moved in between May 18th, 2021 and May 16th, 2022, the website has a chart that describes the different types of increases you could have taken during that roughly 1 year period. It's sort of the equivalent of a sliding scale. You want to look at that chart for two reasons. One, if you took an increase and you still have that tenant in place, or if you took an increase and maybe that tenant moved, there might be the chance that tenant may have been overcharged. Again, the chart is really good to describe the percentages you would have been able to take between this time frame. It's less than 6%, it decreases with time. If your tenant moved in after May 17, 2022, and of course it's the same tenant, you get the current annual general adjustment. It's the first annual adjustment granted by the Pasadena Rent Board. The AGAs are hardwired into the ordinance. That's based on the percentage of the consumer price index. And again, the thing to realize, no banking. So if you have a tenant that is somewhere in this time frame and did not take increases, you have lost them. But yet, I mean, you haven't lost the 2.75% because you're still within that time frame of October 2023 to September 2024. But the first two up on top, those AGAs have been lost. Okay, thank you so much, Allison. So we're sort of wrapping up, and as I said at the beginning, there are 4 components of the ordinance that we didn't have time for that I did want to just touch on. And the first one is under the Pasadena Rent Stabilization Ordinance, tenants are entitled to interest on the security deposit. And I believe the first interest rate is 0.41%, so a little bit less than half of 1% for the property owner to be aware of. This provision of the ordinance does not take effect until January 2025. The second component is rent registry. That is a program, a component of the ordinance, I think, that is being worked on. It basically will compel property owners to register their units by providing certain data points for each unit and property wide. That's being fleshed out now, but you can see in the ordinance, it talks about what you are going to need to provide the rent board in the rent registry. That is in section 1812. The third piece that is in the ordinance is something that's called the tenant buyout program. And what this basically is what it sounds like. The landlord and the tenant agree for the tenant to surrender possession of their unit, usually in exchange for something. And that something is usually money. It could be something like waiver of rent. It could be returned as a security deposit. It could be money. And that money, there's a very wide spectrum. It could be, like I said, just a couple of months. It could be in the six figures. In my previous practice and previous lifetime as an attorney, I saw a wide spectrum of what a buyout would look like. They are all very case specific and fact specific. The tenant buyout provision of the ordinance is found in section 1810, and there are requirements in there. But again, we just didn't have time to go too deep into it. And finally, the petition hearing process. The ordinance does provide for a hearings process through the filing of petitions by both landlords to raise the rent and tenants to reduce the rent. That you can find in sections 1813 and 1814 of the ordinance that describes how those hearings are going to work. And of course, the agency will be passing regulations and getting a staffing model to have hearing examiners to start hearing these types of cases. And that will happen, of course, in the future. So those are like just four other pieces that we just didn't have time for. And that sort of wraps it up on this sort of general overview. I want to thank you. This last slide, you see there are links to the actual charter amendment. The Pasadena website has a lot of the forms that we've talked about before. And if you want to or need to contact a housing counselor, there is the email address rentalboard@cityofpasadena.net. And as Allison was saying, there could be a backlog and it could take a little bit of time. Please be patient. The counselors are doing an excellent job getting to your questions. Some are easy to answer, some are not. So they're doing their best. So that does it for me. We can take questions. I do want to thank everybody. It's been a pleasure being here and helping you at this introductory phase. Thank you so much.
Thank you, Matthew. And at this time, I'm going to pass it to my colleague Agnes so we can work on getting some of those questions addressed. Thank you.
All right, so thank you to those who put their questions in the chat in the Q&A chat. We've answered some of them, and I've been kind of theming some of the questions that came in. And just have to preface all this. We're unable to answer questions about your individual housing situation or case in this workshop. We may be referring you to send an email to rentalboard@cityofpasadena.net if you want more detailed responses. But this the first kind of type of question, Matthew, that we received is around condos. We actually received several questions around this. So can you just clarify how condos, to what extent condos apply, to what extent Article 18 applies to condos?
Sure. And I see Nazanin is with us. Nazanin, if you want to pop in at any time, by all means, feel free. If there's a nuance to it, or of course, if I'm getting something a little wrong, by all means, please jump in. So condominiums are not categorically going to be exempt from your rent control ordinance. I like to sort of think of condominiums as a single family house. So if you have a condominium that's being rented fresh like a single family house, there is a good chance you'll be exempt from the rent control setting provisions. Condominiums that are being rented will almost always be covered by the eviction protections. Of course, you want to look at when this condominium/condominium complex was built. because it might otherwise be exempt, but not because it's a condominium.
And does this
Oh.
relate to, go ahead, Naz.
Oh, no, I was just going to say the only nuance to that is if those units are still owned by the developer, then that is, the person who subdivided the condos, then they are likely not exempt from the rent control provisions of Measure H.
We also got a question about affordable housing. So if there are properties that are deed restricted and used as affordable housing because it received public funding, like say from HUD, but they're not specifically an inclusionary unit or a density bonus unit, are they exempt from Article 18?
I'm going to turn that over to Nazanin.
Sure. So this is another situation where it's not like categorically exempt or not exempt. There are certain categories that will be exempt. For instance, if it is a tax credit property that is owned, operated, and managed by a nonprofit organization, then it would be fully exempt from both the rent control and just cause provisions of the charter amendment. If it is a property that is owned by a government unit, so a government agency, or managed by that government agency, then it may be exempt from those from the provisions of the charter amendment if there's a specific regulation under state or federal law that exempts those types of units. However, if it's not any of those types, if it's a tax credit property that is not necessarily owned by a nonprofit organization, or if it receives some sort of local funding that required a deed restriction, then that does not, then those types of units are likely not exempt from either the rent control or the just cause provisions of the charter amendment.
Matthew, kind of the final question around exemptions, and kind of you provided an overview of this already, but can you just clarify how Costa-Hawkins applies to Article 18?
Sure. So again, Costa-Hawkins exempts from the rent control provisions what is thought about as new construction. Units or properties built after February 1st, 1995 are going to be exempt from rent control provisions, whether it's a single family house that's being built after 1995 or a 200-unit apartment complex. Those units will not be exempt from the eviction protections from the rent control ordinance. That's sort of the easiest way I can describe it. I don't know if that's sufficient. I don't know, Naz, if there's any other way to sort of, describe, how Costa-Hawkins works. Let me know by all means.
No, I think that's correct. Yeah, it's, those ones that receive their certificate of occupancy after that date, or the ones that are separately alienable, such as the single family homes and condominiums that we just talked about. I think the other thing that Costa-Hawkins does is it creates vacancy decontrol, which Matthew did go over, but just to reiterate, that means that when a unit turns over from one tenant to another, the regardless of what type of unit it is, whether it's in that 200 unit building or it's in the 10-unit building, regardless of when it was built, unequivocally the landlord has the right to set the initial rent for that unit. And so a rent control in that, the rent control provisions of the charter amendment do not carry over from one tenancy to another. There's a resetting of the rent that happens between tenancies.
Yeah, and I think I might not have made that clear about the vacancy decontrol component. It applies to all units, whether it was built in 1942 or 2022. So I'm not sure I made that really clear earlier on.
Yeah, we actually had a question like that in the chat. So thank you, Naz and Matthew, for clarifying that. We also got a series of questions around lease renewals. Matthew, you had talked about what happens when a tenant refuses to sign a substantively a lease with the same terms, but is a landlord required to provide a reason for not renewing an annual lease for a single family home?
No. So, the landlord, what the ordinance allows is, the way I like to think about it is, the ordinance gives you, the landlord, the power to compel renewal at the expiration of the lease. You don't have to. You can let the lease expire. When the lease expires, however, that is not a good cause for eviction. And that's sort of the important sort of dynamic that property owners have to start thinking about. Oh, your lease has expired, it's time to evict. You would see this often in a non-rent control jurisdiction. I'm going to rent to you for a year. At the end of the year, I get to decide whether I want you around or not. That's no longer the case with eviction protection. So the expiration of a lease is not a good cause for eviction. But the other way to think about it is, as a property owner, you don't have to give your tenant a reason to not renew. What happens is that tenancy would automatically convert to a month-to-month tenancy. So the tenant doesn't go away, and you get to, if you're the property owner and you don't want tenants on a 1-year lease, you're not compelled to do it. Now, your lease might have some language about automatic renewals that talk about that, and that's going to be case specific that I can't really get into because that's going to depend on language that may be in your rental agreement. But in general, you don't have to renew, and you don't have to give a reason as to why you're not renewing. And as far as the time frame, that's an interesting question. So in my past practice, I've seen leases that try to compel a tenant to give notice many months in advance. And, when I say many, I mean 4 months, 3 months, 5 months. As far as I know, the law is unclear on, what's that time frame. I generally, in my years of experience, do not think that that far out in time would be deemed reasonable should this matter end up in court. If I'm thinking about it from a property owner point of view and what is a reasonable time to start asking my tenant to renew, it's a month in advance or 2 months in advance. But the thing to be cognizant of is that the eviction, and I just want to take a quick look, I think what it says is that when the lease expires, that is when the eviction right, the owner kicks in. And so you might have a provision that might be reasonable that says, 30 days out, month 11, it's time for you to decide whether you want to renew or not. What do you do if the tenant is quiet, doesn't know, or doesn't want to tell you? And you're getting closer to day 365. I believe in this ordinance, you don't have the right to evict until day 366, when that lease has expired. Now, you might think, as a property owner, that's a drag. That puts me in a pickle, and you are absolutely right, because you're trying to figure out what's going to happen on this property. In my experience, I did not see this really become an eviction in most cases, but that doesn't mean it is not an issue that gets disputed often between landlord and tenant. So the best advice I can give is to make your provision for renewal not be exorbitant. I would say not longer than the 2-month mark, 10-month mark, right? In a 12-month lease. And try to be in communication with your tenant in good faith. But do be aware that for a number of reasons, your tenant might not be giving you an answer. They might not honestly know. They might know and they don't want to tell you. Who knows? Every case, again, is going to be unique. And again, realize that I don't believe you would be able to start an eviction, right, in month 10, when the tenant, let's say, tells you, I'm not going to renew, because they can always change their mind 2 days later.
Okay. And one more question around lease renewals. You had mentioned that there is lease renewals with the same terms, and we had a clarifying question. Does substantially same terms include kind of the same terms of the original lease plus the new rent amount with the allowable rent increase?
Yes, that would always be allowed. Yes, you're not locked in. If you start a rental agreement for $2,000, it's not going to be $2,000 for the next 10 years, because under the theory that that's the same term. Allowable rent increases under the law will always be allowed.
And we had a question around one of the exemptions for owner move-in evictions, where a property owner occupies a unit on the property, or if a vacancy already exists on the property. So in this case, and this is a pretty specific case, so Matthew, I can kind of intuit your answer. But in this case, this person was asking if the property owner was living in an ADU on the property and renting out the main house, but now would like to move into their main house, which may be bigger. Would this exemption prevent them from conducting an owner move-in eviction?
Can I actually
So
jump
again,
in?
yeah,
Sorry.
sure, go ahead.
Yeah,
I was just gonna read.
I was just going to mention for this question, because the rental housing board will actually be considering regulations tomorrow night at their regular meeting at 6 p.m. related to these owner move-in provisions. And one of the things that those regulations as proposed would do was explain what this specific provision means and what it means for there to be a comparable unit in which the landlord or the relative are living. And so if this is a concern to you and you want to come out and sort of voice, of in what instances that should be applicable, and I would encourage you to do that, because I don't think that we actually have a good answer to your question. It's a very fact-specific question, and it will rely on what the definition of a comparable unit is that the rental housing board ultimately ends up adopting via regulations, either tomorrow night or at a future meeting. But tomorrow night is the first night that those regulations will be considered. So I just wanted to jump in and say that piece, because I think that it's a good opportunity for people to engage if this is something they're concerned about.
And for those listening in the recording, that would be the October 25th board meeting. And I believe the draft regulations are in the October 25th board packet, if you'd like to look through that on your own. Matthew, this is a topic that you touched upon, but not really dived into, but this is around kind of temporary relocation and relocation assistance required for temporary relocation. So can you share a little bit more about what the charter says around temporary relocation?
Yeah, I'm not, you gotta sort of go over that one. Can I actually see that question? Because I'm not quite clear when you say temporary relocation. Do you mean temporary eviction?
Temporary eviction. Sorry about that. Yes.
Oh, okay. So I don't know. Let me look at the slide, right? So some evictions are temporary. If the landlord is evicting to do necessary, we don't have to look at the slide. If the landlord is doing the eviction for necessary and substantial repairs, that is not a permanent eviction. An owner move-in eviction is a permanent eviction. An Ellis Act eviction is a permanent eviction. Evicting for a lease violation is a permanent eviction. The tenant doesn't have the right to come back. Necessary and substantial repairs is a temporary eviction, because the concept is you're fixing the unit and the tenant would have a right to move back in. So again, through no fault of the tenant, they have the right to return. And that's the case for Ellis Act and government orders to evict. Those are the grounds where the tenant has the right to come back.
And
I hope that
sort of to piggyback again off of this is another piece of those just cause for eviction regulations that will be considered at tomorrow night's, the October 25th Pasadena Rental Housing Board meeting. So
I know that this person who posed this question, I know that there are more details they included, and I would just like to encourage them. Unfortunately, we can't answer we can't respond specifically to your individual case on this workshop. And I really encourage you to write an email to rentalboard@cityofpasadena.net so our housing counselors can provide more detailed, individualized response to your question. We also got a series of questions around relocation assistance. And I think the first kind of question was when the relocation assistance regulations went into effect. So in this case, if someone was evicted for owner move-in before the relocation assistance regulation was passed and that schedule, the assistance table was published, How will that be handled? Would they be eligible? Would that tenant be eligible for relocation assistance? I think Nas, this might be a question for you. Is there an applicability?
I think we would need to know more about the details. I don't think that we have the charter amendment says that tenants are eligible for relocation assistance if they were evicted for one of those no fault reasons. And regardless of what the rental housing board decides to do related to that, that tenant can always enforce that right in other ways, such as bringing in action in court. So there's not a good straightforward answer. Kind of giving you the lawyer answer here of it depends. But they likely are still eligible for those, even though the relocation amounts were not yet published at the time that they were evicted.
Yeah, I would sort of agree. So certainly, if you're the landlord and this event happened before the table got published, you didn't know what to pay, but you were put on notice that you did have to pay something. So certainly, if the day the tenant moved out and said, you need to pay me, you would have a legitimate response saying, I don't know what that number is. But now you do. So, like Naz is saying, we're sort of, you know, you know, being a little ambiguous because again, we're not your attorney, whoever's writing this, but there is options that are available to you. You can look at the table, find the tenant, try to reach out and contact that tenant, and make the appropriate payment. You could choose not to if you think you don't have to. And like Naz was saying, there could be potential liability if, should that tenant wish to pursue this right that we are pretty sure they have. So it can play out a number of ways.
We also have a clarification request for relocation in the event of a government order or a red tag. So with that, just to clarify, that if there is a government order or a unit has been red tagged, is the landlord required to pay relocation assistance to the tenant?
Yes.
We also had a question around kind of rent rollbacks. Matthew, so this question asks, if I increased rent after May 17th, 2021 and gave a 3% rent notice in June 2021, can I still receive that rent amount, or do I have to retro it back to the base rent before May 17th, 2021 and then give a new notice now for only 2.75%? So, you may not be able to answer this person's specific question, but can you just reiterate what the procedure is around rent rollbacks?
So tell me again when the tenant moved in.
This, again, they don't say, but I think this is just flagging to the owners who are on this call that a lot of these questions really is determined by the tenancy start date and the unit address to see if they're exempt or not exempt. So when you reach out to a housing counselor, please include those two pieces of information.
Right?
Yeah, go ahead, Baz.
No. This is on a different question. This is on the prior one, so please go ahead with this one.
Yeah, so for this one, the website has the tenant rent rollback form. For this particular landlord, you might want to go look at that form and fill it out. It walks you through, I think, step by step, what the rent was, what the rent got increased to, whether or not the tenant was entitled to a rent reduction. And I know it might sound like reverse engineering from the property owner perspective, but walking through that form might give you that answer. I think Naz wanted to answer.
Yeah, sure. I just wanted to respond because I'm seeing this ongoing discussion about what appears to be the question about the government orders related to things that are basically outside of the landlord's control. So the specific language of that just cause provision in Measure H or in the charter amendment provides that where the landlord seeks in good faith to recover possession to comply with a government agency's order as a result of a violation of the Pasadena Municipal Code or any other provision of law. So I'm not sure exactly what the practice of code enforcement is in Pasadena, whether they consider it a violation of Pasadena law if there is, an earthquake that is not within the landlord's control that renders the property uninhabitable. And so I think that that's a little bit more of an iffy question. I think really the intent of this provision is where the landlord has failed to make necessary repairs or has failed to maintain the habitability and the unit has therefore become red tagged. I think those situations where you're talking about a natural disaster is sort of will depend on how the city departments treat those and whether they consider those to be a violation of either Pasadena law or applicable state law.
And the final question that we received is around renters insurance. Can a housing provider require existing tenants to start carrying renters insurance? And how does that work with allowable rent increases?
So I think one way to think about it is if you didn't require it at the beginning of the tenancy, my best thinking, and again, you want to consult the lawyer if you're thinking about trying to impose what is probably a new lease term on your household, because asking the tenant to do something that they didn't have to do at the beginning of their lease, there's a good chance that's going to be considered part of their lease, like the absence of renter's insurance. And then changing it and saying now you have to do it, the tenant will probably consider that to be a substantial change to the lease, which you would not be able to do unless the tenant agrees to it, of course.
I know that people had specific questions about, again, your individual housing situation. I'm really sorry that this is not the appropriate forum to address those questions. So with that, I think that concludes the questions that we received in the Q&A, and I'll turn it back to Allison. Thank you, Naz, and thank you, Matthew.
You're welcome.
Great. Thanks, Agnes. Thanks, Naz. Thanks, Matthew. Yes, go ahead, Naz.
Sorry, because I'm seeing I'm seeing something in the questions that's also being repeated that is not correct. And I just want to clarify that the 2.75% annual general adjustment is only applicable from October 1st of 2023 through September 30th of 2024. The Rental Housing Board is required to adopt a new annual general adjustment before September 1st of every year. And that annual general adjustment is then applicable from October 1st of that year through September 30th of the following year. So it's not that it's going to be 2.75% yearly increase. It's going to be a different amount every single year. The percentage amount is going to be different depending on the formula that is in the charter amendment and that the Rental Housing Board will use to adopt the AGA annually. So I just don't want people presuming that they're going to apply 2.75% every year from this, starting this year and every year thereafter. You have to check back in yearly to see what the allowed rent increase is for that applicable period.
Thank you, Naz. And there's actually one last question in the Q&A that I'll answer regarding why are there no landlords on the board. Actually, there's at least one landlord on the board. But thank you for the question from the public. So looking at the time, it being 8 o'clock, wanting to be respectful of your time, we appreciate all the questions and the clarifying answers, but also the clarifying questions from the public. We'll continue to push out forms, additional information as we are developing them. I also would like to remind you all about the survey. There's a post-event survey. We'd really like to learn how you all found out about this event and additional questions. If you do, in fact, contact the rental board at cityofpasadena.net, like we said, there will be, unfortunately, a delay as we continue to staff up. But should you wish to do that, please include the date that the tenancy began and the exact address of the unit in addition to your questions. The rental board meets every second and fourth Wednesday. Tomorrow we meet at 6 p.m. at the Jackie Robinson Rec Center. These schedules in November and December will vary because of prior reservations for the space. And finally, all information for the rental board forms, fact sheets, meeting times, you can find at cityofpasadena.net/rental housing board. And I'll add that to the chat before we close out tonight. We thank you again. We apologize for the previous workshop having audio issues and are greatly appreciative for everyone who returned this evening. And with that, I wish everyone a good night.
Thank you, everybody.